Let's take a look at English-only rules. Employers with bilingual or multilingual employees sometimes institute English-only rules that prohibit or restrict the speaking of languages other than English in the workplace. These policies vary in breadth, from total bans to time and place restrictions on when other languages can be spoken. The impetus for establishing these policies is often the complaints of monolingual English-speaking employees who believe they're being denigrated. Safety concerns, customer preferences, and problems in supervision are also cited as motive. In 2010, about 20% of the US population age 18 and older spoke a language other than English at home at least some of the time. Among foreign-born persons, nearly 85% spoke languages other than English at home, with Spanish being the most common. English-only policies stand to have a particularly detrimental effect on Latino employees. The EEOC's guidelines hold that broad English-only rules applied at all times are presumptively discriminatory. More narrowly tailored policies applied only at certain times are legal, provided that employers can show their business necessity. The EEOC also maintains that unless employers notify employees of the existence of an English-only rule, any disciplinary actions taken against non-compliant employees will be viewed as evidence of discrimination. Some courts have held in disparate impact claims that English-only rules do not adversely affect the employment opportunity of bilingual employees because they're able to comply with the policy. Consequently, there's no need for the employer to even show the business necessity for their English-only rules. Courts have also found for employers when the English-only rules were not overly broad and rigidly enforced. In one such case, a retail store employee was required to speak English when on the sales floor and in the presence of customers, and expressly permitted to speak other languages in the workplace at all other times. The court agreed with the employer that the policy served the business necessity of promoting customer service and rendering salespeople more polite and approachable. These rulings do not amount to blanket authorization for English-only rules. Monolingual employees who speak languages other than English are unable to comply and disadvantaged if the policies are enforced against them. Combined with other forms of hostility to foreigners, rigidly enforced English-only policies contribute to hostile environments and national origin harassment. Public employees may be able to assert First Amendment speech rights if their government employers limit them to speaking English on the job. If used at all, English-only rules should be no broader than absolutely necessary to accomplish a legitimate business purpose. Enforcement of these rules should not be rigid, and employees must be clearly notified that the rules are in effect.